Welcome, everybody. My name is Professor Errol Mendez. I am the president of the International Commission of Jurists, and I am delighted to welcome you to this event, which is a collaboration between the University of Ottawa's Professional Development Institute in collaboration with my organization, the International Commission of Jurists Canada. We welcome in particular Liberal M.P. John McKay and Senator Julie Miville-Dechêne, who are co-chairs of the All-Party Parliamentary Group to End Modern Slavery and Human Trafficking. They will be presenting on the historic Federal Modern Slavery Act, which takes effect on January the 1st, has taken effect on January the 1st, 2024. The presentation that they will give will be followed by one of the top experts in Canada on the analysis of the law, Benedict Ray from the national law firm BLG. Now, the Modern Slavery Act is advertised as strengthening Canada's international commitments to universal human rights, to develop more transparency in supply chains, and to contribute to the fight against modern slavery and child labor. The Act will mandate companies to report on their efforts to prevent and reduce the risk of forced labor or child labor in their supply chains. It will also allow the CBSA and the Minister of Public Safety and Emergency Preparedness to impose import bans on goods and materials partially or fully produced by forced labor or child labor, and, if necessary, to issue fines to companies who have failed to report or produce a false or misleading statement. Now, this virtual event is a partnership, as I said, between the Professional Development Institute at the University of Ottawa, which is one of the top professional development areas of expertise involving some of the top experts in many different fields, and is unique in terms of its expertise in Canadian universities. It is also a collaboration, as I mentioned, with the International Commission of Jurists, so permit me to give a few words about this organization. The International Commission of Jurists is a registered charity with members from across Canada in the legal community and the general public, and has been promoting as its mandate the rule of law, human rights, the independence of judiciary, and promoting fundamental democratic principles and institutions since 1958. So we welcome everyone across in this who have signed on to this event to join us as supporters from across Canada. We have over 500 people at this event, and to support our work through donations, in that regard, please visit the International Commission of Jurists website at www.icjcanada.org. All donations will come with an official charitable tax receipt for the full amount. Now, with that, I would like to introduce both parliamentarians who present their view of this new law in their own words and based on their own experiences leading up to this law. Let me start first with John McKay. The Honourable John McKay was first elected as Member of Parliament in 1997. He was re-elected in September 2021 to serve his 9th term in the House of Commons. He is currently representing the constituency of Scarborough-Gilwood. His current roles include: he is the chair of the Standing Committee on Public Safety and National Security. He's also a member of the Special Committee on the Economic Relationship between Canada and the United States. And as I mentioned, together with Senator Julie Miville-Dechêne, he is the co-chair of the All-Party Parliamentary Group to End Modern Slavery and Human Trafficking. Born in Toronto, in Ontario, he has a Bachelor of Arts degree from the University of Toronto and a Bachelor of Laws degree from Queen's University, and has practiced law before becoming elected to Parliament. Let me have the great pleasure of introducing Senator Dechêne. Since her appointment to the Senate in 2018, the Senator has been one of the key players in many of the key issues surrounding issues related to, for example, forced labor and child labor, and more recently, in terms of making it mandatory to implement age verification to protect minors from online pornography. She is the vice chair of the Standing Senate Committee on Transport and Communication. She has had a long career in the public service where she has stood out for her talent as a communicator. In her early career, she has devoted herself to journalism, a career that took her across Quebec, Canada, and the United States for more than 25 years. She was also the first woman ombudsman of Radio-Canada and was also named as the chair of Quebec's government's Conseil du Statut de la Femme. She holds a graduate degree in conflict prevention and resolution from the University of Sherbrooke, a master's degree in journalism from Columbia University, and a bachelor's degree in political science from the Université du Québec à Montréal. With that, I would like to introduce John McKay to give his presentation. John, over to you.
Thank you, Errol, for this opportunity, and I appreciate the understanding that Julie and I will present together. My thought would be that I'll start it off, then throw it over to Senator Julie, and then we'll bat it back and forth till we get to where we are today, which is looking at the guidelines for implementation of the bill. So the bill, for me, starts in a colleague's office when World Vision introduced us to a British lady from the House of Lords and Ladies. And she was advocating on behalf of the British government. They had passed legislation, and she was hoping that that Canada would do something similar. I thought that was quite a good idea, and World Vision were the constituency that were advocating, and and having done a few of these bills in the past, I thought that this was quite a useful constituency. But they also came with a memo from Dentons, which many of you will know as one of Canada's leading law firms, which helped us craft the bill so that we didn't fall foul of constitutional issues. Many of you will know that the chances of getting a private member's bill from tabling to royal assent is pretty modest, probably less than 2%, maybe even less than that again, especially for a bill that's of substance such as this one. There are, of course, bills that do get through that modify the name of a riding or something of that nature, but by and large, substantive bills are very difficult to achieve, and this is quite clearly a substantive bill. And I frankly think it's a flaw in our parliamentary system, but the way the system currently works is that if we are fortunate, we draw a number at the beginning of the Parliament, and for those of us who are not in cabinet, and that number is a private member's business number. And if you're in the top 30 or 60, you've got some likelihood of being able to present a bill. After that, you're probably not going to be able to do so. And so in the first iteration of this bill in 2018, we had a lot of help. We had help from World Vision, we had help from Dentons, we had a draft bill, or actually a real bill from the UK, and a draft bill from Australia. And so we were able to go to the legislative drafters and put something together that was useful. That bill was tabled, but it went nowhere because Parliament was dissolved. So 2019, we decided to do something similar, and that's a point where I met Senator Julie Miville-Dechêne on an interesting trip to Bolivia, where they decided to start a South American revolution just as we arrived. And so we had a harrowing few days of not only getting into the country, but at the crack of dawn, weaving our way out of the capital city to the airport around various road blockages. And so we consider ourselves fortunate to have actually gotten out of the country, which is kind of a characteristic of this bill, that it's full of miracles, both minor and major. And
This was a major
yeah,
miracle.
we started off with a major miracle.
Because, John has a particular sense of humor. We met in Bolivia. It was not the easiest meeting. And then we realized we had pretty much the same values. Obviously, John had a lot of experience. I had none. But on that particular bill, I just want to say that John is very modest, but it's because of his indignation in a system that is so big with so many MPs that it's very difficult to push and to succeed. He was tired of waiting for the government to act on this particular issue, which had been discussed in committee and which was happening elsewhere in the world. There were legislation being passed, and he just didn't take it. So that's why he was looking for a partner, because he just explained the system in the House of Commons, which is not the same as in the Senate. In the Senate, we're a small chamber. We have now about 90 senators, and it's not a lottery. First come, first serve.
Which is what we used in 2019. Because Julie could get herself up on the order paper much more quickly than I could, and that almost worked. Almost.
The problem was, and then this is the pandemic at its worst and its best. The worst part was there was a prorogation, then there was an election, so I just had to come back with the bill. In the meantime, we made it better. We had time to change and refine the language. And we have to be frank about it. The pandemic, in a way, did not help us, but in another way did. Because, there was an increase in forced labor. The visibility of this particular issue was upfront. There were allegations, I don't know if you remember, of the government, the Canadian government buying Max medical gloves in Malaysia. So, the government was itself involved in allegation of contributing to forced labor, which was pretty scandalous.
Yeah, and that was your major contribution to the bill, frankly, was to incorporate government responsibility. Our theory being that we could hardly ask other Canadian entities to adhere to this kind of legislation if we as government representatives didn't do it ourselves. So, yep. And the other benefit of the next election, which was that both parties, both the Conservative Party and the Liberal Party, put it into their party platforms to put forward legislation on supply chain slavery. And that actually worked very much for us.
Absolutely, because it was in the public sphere. The supply chains were completely deregulated. People were talking about it. I remember even in the House of Commons, you had committees where you were talking to the government about this China imports, how we were checking if it was made with slaves or not slave. So really, all of that contributed to the context. And what happened from my point of view is that obviously I was trying to meet as many business and NGOs as possible. You have to build some coalition inside and outside. And this proved to be very difficult. First of all, the business were completely in the COVID, had problems, were not very open to anything new in terms of responsibilities. And business is not, they were not open about, some of them thought our bill was a good first step and was important, but they were not speaking about it openly. They didn't want to speak about it. They didn't want to come in committee. Nobody wanted to put its head out of the water. So we had this on one part, and then we had the NGOs defending the human rights saying this bill was just, it was better not to have a bill than have that particular bill, that it was nothing, that it was too careful, that it was just a piece of paper. So we had both, extremes. And I tried, and John helped me so much to keep this consensus, because you need a consensus inside a chamber to have a vote and pass a bill. It's not just a question of making the bill, at the maximum level. It's a question of passing the bill. And this is what I'm learning in politics, that
And the other thing that we made a strategic decision about was that we would do a transparency bill as opposed to a due diligence bill. And I'm sure Benedict further on will talk about various countries that have adopted a due diligence piece of legislation. But we felt that that was kind of a bridge too far, given that the coalitions were a little shaky, shall we say. On the NGO side, there's a considerable element that still wants a due diligence bill. And but I have to say that the business community came around quite quickly, and it's really kind of how do we comply rather than should we comply, or is this a good idea or a bad idea? Because no corporation wants to see themselves on the front pages of the Globe and Mail being accused of using child or slave labor in order to be able to sell products in Canada. So and that part became easier and easier to sell. And the other part of the coalition is to keep the government on side, which is sometimes very tricky, because if the government starts to see that you're having some success, and Julie had some considerable success in the Senate, and now it's bounced back over to the House. Now we had a backup plan involving our good friend Marcus Pulowski, and I traded a nothing for a position on the order paper as a backup plan. But as it turns out, we didn't have to use the backup plan because Julie was successful in getting the bill onto the floor of the House.
But if I can interrupt, just to add a little detail. So it was adopted, obviously, in the Senate. The Conservative and most independent were for it. And we almost didn't have any amendment. We chose to keep the bill as is, except for one amendment, and I want to tell you about it because it's an interesting story. Senator Djerba, who was born in Cameroon, was on this committee, and she says, well, what about after, the supply chain is cleaned out and the kids are returned home? What happens after? They feed their family. Obviously, she had been born in Cameroon in a poor family, and herself had contributed to fill the needs of her family. So, as you know, it's a transparency bill. It's not a due diligence bill, but we added an amendment saying that the company had to report on the remedial measures they would take if they had to let go some employees because of age, because of conditions. And I thought this was an, interesting touch to what a senator or MP can bring to a bill.
And that kind of speaks to the issue that this is kind of due diligence light. And for those of you who are trying to advise various corporations and entities on compliance, the anticipation is that the government will be asking for more information over time, more compliance over time, and if you read the guidance that the government has issued, there is quite a narrative on due diligence. So we bounced the bill out of the Senate onto the floor of the House, and suddenly the government is starting to pay attention, and you have to be careful about the embrace of government, because it's generally, oh, this is a great idea, but we think we can do better. And my point with the various ministers was, well, you've had a lot of time, like 4 years, to do better, and you haven't done anything. So let us proceed. And let me say, these are not conversations that are without some danger. One of which happened in this in my office here with the minister, who was very keen on amending the bill. And that became a bit of a focal point as we got the bill off the floor of the House and into committee. The minister had a whole package of amendments that he wished to put on the bill, which I think would have sunk the bill. The problem with amendments is that as soon as you do that, then it has to bounce back to the Senate, and you lose control of the bill. And instead of talking about a bill that's got royal assent, at this point, we'd be talking about a bill that's in the Senate and Lord knows going anywhere at all. So Senator and I finally appeared before the Foreign Affairs Committee, which is where the bill was directed. The Foreign Affairs Committee had been engaged in a filibuster for quite a while and had pretty well run out the clock. You have 60 days from referral to a passage, a second reading, to deal with the bill. Otherwise, it's deemed reported back to the House. And as I say, the Foreign Affairs Committee had pretty well run the clock because of the filibuster. So we had a very superficial review of the bill, but had to maintain the solidarity of both the Liberals and the Conservatives, because at this point the NDP and the Bloc had abandoned the bill and wanted a much stronger bill. We got the bill back on the floor of the House, and
this was because, I want to say, because once again, John is very modest. This is because of his experience. I was looking at that, being completely flabbergasted by the fact that John, every time an amendment was put to the floor, he was saying, no, if we take that, it's going to kill the bill. And he just continued and continued. And it took a lot of strength, because it could have gone both ways. There could have been some there could have been some votes who would escape him. So I admire this, but I think it took his whole experience of life to do that without doubting. Maybe you were doubting, but it didn't show.
Well, I did become Dr. No, and it's not as if there wasn't merit in some of the suggestions. And the irony was that Julie and I were effectively filling 4 mandate letters for 4 separate ministers. And the reality is that that none of us know when the mandate of this government will end, but knowing the legislative process for getting even fully supported government bills from A to Z is a torturous process and fraught with difficulties. I felt fairly strong that I should be Dr. No, and that we are sort of proceeding with what we've got, and we're going to stay with what we got. And ultimately, we got the bill passed. 271 Liberals and Conservatives, and 57 Bloc and NDP against. So yeah. It's a pretty strong mandate.
And because we decided not to let the perfect be the enemy of the good, exactly. And because we decided that we were strong in defending our bill, which was probably the strongest of the transparency bill that are around the world now, in the sense that government is included, in the sense that if administrators make false or misleading statement, they can be fined. It's an infraction, so there's punishment, which there isn't in UK and Australia, if I remember well. So this is not a bill without teeth. Obviously, it's not a due diligence bill, and we all agree on that. But it's also the question of where does business stand, and is it better to have this first step and tell business this is serious, please take it seriously, or nothing because it's not good enough. And we chose to defend the bill.
And so Canada has gone from laggard to leader in this space, and I think is to the credit of many of you who have been very helpful in this process. Once we got royal assent, you'd think that we could, sit around and drink Mai Tais and put our feet up, but of course, then the government started asking for an extension of the January 1st date, and because there's 450,000 civil servants in the government of Canada, and they all live to say no. We can't do it, or we're too busy, or whatever. So that next became the project of harassing the Minister of Public Safety and of course we changed minister right in the middle of the harassment, so we had to start a new harassment all over again. And to the great credit of the Minister of Public Safety, Dominic LeBlanc, we did get these guidelines and regs passed or published on January the 1st. It was a bit of a cliffhanger exercise. All of you, presumably, or many of you, have access to those, and I'm sure Benedict and others will speak extensively about them. So that's kind of where we're at right now. There are a couple of things that we are talking about, and is that we would like to coordinate the British and Aussie legislation so that filings are made as easy as possible. I'm in Australia. Interestingly, I just came back from Australia, and I met with my Australian counterpart, and he's quite keen on this. And the Honourable Theresa May, former Prime Minister of Great Britain, is also very keen on some coordination. So that may be an area that we go to. And finally, I just subject to what Julie has to say. I just say that it's likely that some government will introduce some form of due diligence legislation at some point. My own view is that it's not going to be this government, and it's not going to be this mandate, other than it may introduce a bill that is for, how should we say, virtue signaling more than reality of getting it passed. But I do think that, as I say, this is a bit of a miracle bill, both major and minor. The chances of getting a private member's bill from zero to royal assent is, as you say, less than 2%, and a substantive bill probably less than 1%. So I thank you to my co-conspirator, and look forward to whatever you have to say. Julie, have you got any final word?
Well, a final word. We thought a lot about the language of this bill, and maybe we haven't talked much, John and I, about it. But, if you go and look at the definition of child labor, we tried to make it a bit more extensive than just the worst form of child labor, because we believe child should go to school, should have time to do something else than work in a mine. So we harmonized also the disclosure statements. So there's already some work being done for companies who are already reporting in the UK and in Australia. So the bill was a bit rewritten to add that. So, it's a bill that's obviously not perfect. The regulations, I've talked to other jurists and lawyers who still find, there is why is there a questionnaire on top of a reporting? So people are business are asking a lot of questions. But I always say, I think it's a question of taking the exercise seriously and thinking that things will get better and more precise, probably, in the first year. I think in a lot of bills, that's the way it goes. You start, nobody knows exactly, all the details, and then things get clearer. So I'm very proud of the work we've done. We know exactly what are the limitations of this act. we hope it's not going to be a click, an exercise of tick the box. This depends on the business, really, and the lawyers who are giving them some advice. And I'll stop there.
Thank you very much, Senator John. We greatly appreciate your taking time to present how you got the bill to fruition and your hopes for how it will happen and be further strengthened in the future. We only have time for about 1 minute in terms of, we've got lots of questions in the question and answer, but I don't think we have the time to all of them. But let me sort of summarize some of them basically by saying, if it's not a check mark approach, and if further work needs to be done, how do you respond to very credible organizations like Canadian Labour Congress and Amnesty Canada saying this is not enough? And how do you go further than just dealing with what they're calling primarily a reporting obligation on the part of companies? Do you want to have a very quick response to these credible organizations? They're not, fly-by-night people. So how would you respond just in a minute or so?
Julie, why don't you give the diplomatic response, and I'll give what I really think.
Well, eventually, I think due diligence will come if this doesn't work. I'm a pragmatist. This is the bill we could pass in our legislature. This has qualities. The idea that companies start to reflect on that issue, to do some work, is not to be taken lightly. The ONGs, I respect their opinion, but it's not always by saying, we are not perfect, so let's just drop a bill, that we progress in society. I think we have to believe in a step-by-step approach, because those are huge changes. I realize, I'm very attached to violation of human rights. Forced labor is a terrible violation of human rights, but it's not only linked to supply chain. It's a huge problem. So we have to take it bite by bite. And one of the other bite is to give more money to those countries to have human rights respected. There's a whole lot of things to do, and this is a part of the puzzle.
I would be a little bit more harsh. First of all, I think that compliance with legislation is critical. And we felt that a transparency bill such as this would achieve a fairly high level of compliance. The other side of it is that a due diligence bill necessarily requires a shrinking of the pool of companies that have to comply. So in our case, the thresholds are 20 million in assets, 40 million in sales, and 250 employees, 2 out of 3. And the other legislation, France and Germany, the size of the companies would shrink the pool down to maybe 100 or 200 companies in all of Canada. Well, that to my mind, that's completely unacceptable. So the appearance of due diligence is just that, and we're advised that the compliance in those 2 countries is pretty modest.
Yeah, and you don't change mentalities. We know that slave labor, forced labor, is in the medium-sized companies where there's not enough checking. So you just can't go with 100 companies per country and said the job is done. This is, for me, I think our model has some qualities that it should not be ignored.
Be careful of the siren song of due diligence. And let me just end with this, Errol. I was on a trip to Taiwan, and I was leading a delegation. It just so happened that 2 of the critics of the legislation were on the delegation. So I thought I'd use my general charm and persuasiveness to convince them that they were wrong. And of course, I had no success whatsoever. So the irony was that there was a conversation in the bus as we were going to some other event, and one of the critics is married to a corporate lawyer, and he was listening in on the conversation, which, as I say, was going nowhere, and he piped up and said, "Oh, this is the bill where all my corporate lawyer colleagues are complaining that they're going to figure out how to comply with the bill." And so I think in that respect, it is a bill that where it's going to be initially difficult to complete the documents, but and I don't think that many years, it's going to be kind of a routine part of corporate social responsibility. And this becomes a part of an expectation of doing business in Canada. The other thing that I think will be really interesting is the interaction with the Canadian Office of Responsible Enterprise. I'm quite looking forward to the filings on the part of Nike or Zara or various other clothing companies, and the investigations of the ombudsperson. Those are going to be difficult filings, but hopefully between one thing and another, we will up our corporate responsibility game. So again, thank you for this opportunity.
Thank you very much. Now, just for the audience, I do know there's some very technical questions that have been asked. We will hope that Benedict will answer some of them after his presentation. But meanwhile, I really want to thank both of you, Senator and John. As the Senator has said, perfection is often the enemy of the good, and time will show that sometimes you can basically get through to perfection through a process of transformation over time. So maybe we will get that perfection eventually. So let's hope that that'll happen. So thank you very much for both of you, and we really appreciate your presentations. And we will be sending you the recording of this, and perhaps feel free to use it for whatever purpose you can. Thanks again.
Thanks again. Thank you.
Thank you.
So we're now going to a presentation by Benedict Ray, who is an expert in this area. I'm just going to repeat his bio before he appears. Benedict Ray is an English and Ontario qualified lawyer with the law firm BLG. His practice includes international arbitration, commercial litigation, administrative law matters, as well as a range of business and human rights issues. He has experience in investor-state disputes, advising and representing clients on international commercial arbitration, also in Canada and the UK. Before joining BLG, he worked both as a barrister in chambers in London and at a global law firm. He has represented his former firm in consultation by the Canadian government regarding this very legislation on modern slavery. He is a member of the firm's environmental, social, and governance initiatives. Benedict, over to you, and hopefully your slides will also start the presentation too.
Thanks very much, Errol, for that wonderful introduction. I hope you can see my slides.
Yes, we can.
Terrific. Well, thank you again for this opportunity to be here. It's a real pleasure for me to appear at this event and alongside none other than the two sponsors of the Act through Parliament. I'm extremely grateful to be able to speak to you all about this. And I hope you won't feel that I'm repeating too much of what the Senator and MP McKay had to say. But I do just want to, before I kind of dive into things, I just want to pick up on something that came out in the very last bit of discussion. I joked to my colleagues that I used to be a disputes lawyer, and now all I do is advise on this Act. And it's certainly true that there has been an explosion of inquiries around this Act. And I know from talking to peers and colleagues at other law firms that that's not something that's unique to us. It's something that's being felt across the board. And so John's anecdote about the corporate lawyer and the complaints he'd received from his colleagues about the new bill, that's now become a reality. There is an enormous there is enormous kind of concern and interest in this legislation from Canadian businesses and across the legal community in figuring out how to comply with this. So this is certainly a phenomenon that is large in scope. Before I just dive into my presentation, I do need to give the general disclaimer that all lawyers have to give, that this is not legal advice, this is general information. I'm qualified, as Errol said, in Britain and here, but I will be touching on legislation that came out across the globe in various different countries. Obviously, if you need advice about those pieces of legislation, you should speak to a lawyer who's qualified in those jurisdictions. The other thing I want to say is, so as I say, I advise on a range of business and human rights issues. I also did my doctorate in this area, so you can see that's up on the screen. I wrote my thesis at a time when something called the UN Guiding Principles on Business and Human Rights was being created and developed at the UN level, which really is one of the things that led to a lot of this legislation that we see here. And so I've been following this for a very long time, and it's been very interesting to kind of see how it's progressed both globally and in Canada. So without further ado, let me move on to the things I want to discuss today. If I have time, I'm going to cover 5 things. We're going to start with looking at what forced and child labor are and how they fit into modern slavery. We kind of throw these terms around a lot, and it's important to understand how they fit in. I'm going to present the sort of range of approaches that we see around the world. I'm then going to talk about the reporting requirements under the Canadian Act, and again, how those stack up to a selected few of the laws that are out there elsewhere. I'm going to touch on the penalties that Senator Miville-Dechêne touched on a few moments ago. I'm going to talk a little bit about how to report and the guidance that's been put out by public safety in recent weeks. And then if there's time, which there may not be, I did want to also touch on how this act interacts with both customs controls in Canada and the Canadian Ombudsperson for Responsible Enterprise that MP McKay mentioned a couple of moments ago as well. So moving on to the definitions. I think it's important to recognize that we talk about modern slavery a lot. It's really an umbrella term. That's important because Canada's Act isn't a modern slavery act. It doesn't call itself a modern slavery act, but in reality, it really is. And here's kind of why. So the 3 things that are said to make up modern slavery, which you can see on the little Venn diagram from the Global Slavery Index, are on the one hand, human trafficking. That's the physical taking of persons, taking them from one place to another, usually under some threat or coercion with an intent to exploit them in the place you're going to. It's usually cross-border. There are a lot of criminal statutes that deal with human trafficking. Canada is no exception. But while that's part of the modern slavery phenomenon across the globe, it's often not one of the focuses of this type of reporting legislation. There's forced labor. That's kind of more straightforward. The ILO in its forced labor convention defines forced labor as work that's performed involuntarily and under the threat of any penalty. And that's largely mirrored in the definition that we find in the Canadian Act, which is work that could reasonably, is offered or provided by a person under circumstances that could reasonably be expected to cause them to believe that the safety of themselves or a person known to them will be threatened if they didn't do the work. And then it has, the Act also has a catch-all that goes back to the ILO convention itself. So forced labor is straightforward. It's a straightforward part of modern slavery. It's generally well understood. It's a huge problem, as we're going to see on the next slide. Forced child labor also fits into this rubric. And that's covered in part by the other 2 conventions you see there on the screen, the ILO Convention 182 and UN Convention on the Rights of the Child. But child labor isn't just limited to forced child labor. It also comes back to this idea of hazardous child labor. And so child labor is also something that fits into the sort of slavery and slavery-like practices part of modern slavery. We generally see this as this kind of final part of the Venn diagram as being a catch-all for situations of exploitation under some form of coercion or threat. It includes forced marriage, which is considered a big problem and part of the modern slavery problem worldwide, but again tends to not be so much the focus of Transparency Acts targeting the private sector, but it is a huge problem. And as I say, hazardous child labor. So hazardous child labor is, according to the ILO, work that is physically, mentally, socially, or morally dangerous and harmful to children and or interferes with their schooling. And as the Senator mentioned a few moments ago, the definition in the Act kind of takes an aspect of that hazardous child labor and extends it a little bit by expanding the interference with schooling part into the definition that we find in the Act. So taking a step back, the Canada's Act is the Fighting Forced Labour and Child Labour in Supply Chains Act, but forced labour and child labour really straddle two of the biggest categories of modern slavery. And it's not to say that Canada doesn't deal with human trafficking as well. Indeed, it does, through its criminal laws and through a number of provincial laws that are in effect around the country. So that takes me to the very next slide, which is I'd just like to throw this up there to show what the scale of the problem that this legislation is aimed at dealing with looks like. You have a map on the right, which is kind of a heat map of the number of people estimated to be in modern slavery as it pans out around the world. And we're considering forced labor. Well, maybe before I come to forced labor, the estimate of people in modern slavery in total is nearly 50 million people. And that's a number that's only rising. When I first started speaking about this 5 or 6 years ago, I was using an earlier version of the global estimates. The 2022 estimate wasn't out, and it was only 40 million then. So it's gone up by nearly just over 9 million people in the last five years or so. There's approximately 17,000 people in positions of modern slavery estimated to be in Canada. Now, the forced labor figures are what come next. There's 27.6 million people estimated to be in forced labor, according to the ILO. 77% of that, 63% of that are in the private sector, and 12% of that is children. The other thing that tends to surprise people is the biggest sector for being at risk or having problems with forced labor is services. After that, it's manufacturing, then construction and agriculture. But services, the estimate is that there's 5.5 million people working in the service sector in a situation of modern slavery. So that's 44% of the adult forced labor numbers in total. When we look at child labor, the numbers are sadly even worse. Now, you'll appreciate from the previous slide, child labor and forced labor are two slightly different concepts. So not all child labor is forced labor, and not all forced child labor is child labor. It covers hazardous child labor as well. There's estimated to be 160 million children worldwide in a situation of child labor, according to the ILO and UN conventions. Approximately half of that, or 79 million children, are in hazardous work. So those are the evils that all of the approaches that we're about to talk about are aimed at combating. And so what are those approaches? What do they look like around the world? There are roughly kind of 4 categories of approaches we see developing globally. The first is transparency legislation. There's often said to be sort of 3 waves or 3 generations of transparency legislation. The first generation is the first sub-bullet you see there, what's called non-financial reporting. An example of that is to be found in the UK Companies Act 2006. And that's legislation that either empowers or requires companies to report to their shareholders on things other than the bottom line. So on things like environmental, social, human rights issues that may affect them and their business. There's most of those were introduced in a voluntary way. Some of them became mandatory in kind of the late 2010s, but they were, by the time that they were becoming mandatory, we'd already moved on to what's called, as I said, the second generation. So this is where we talk about modern slavery acts and where the Canadian Act fits into this. So a modern slavery act model, which is also the model adopted in the States, in the state of California, through the California Transparency and Supply Chains Act, basically requires companies to report on what they're doing. So none of the acts require that you do anything. You can comply with the UK Act, with the Australian Act, with the Canadian Act by saying we are doing nothing. The expectation is that that won't be acceptable to people from a business and market perspective, and so indirectly it may encourage them to start taking action. But the essence of a reporting legislation is you have to say what you're doing about modern slavery in your business and in your supply chains. What's sometimes called the third generation of transparency legislation, but which I kind of like to put in a category of its own, is what MP McKay has already referred to as a due diligence act. And this sometimes gets these kind of funny acronyms of MHRDD or MHREDD. That stands for mandatory human rights due diligence or mandatory human rights and environmental due diligence. This was a movement that began in France in 2017 with something called the duty of vigilance law. There's a version of due diligence legislation in force in Germany and in the Netherlands, and one is expected and in fact a late stage development in the EU. The key difference between a mandatory due diligence law and a modern slavery act model law is that the mandatory due diligence law goes a step further by requiring you to do something. You have to actually develop and implement a plan, and you're then accountable for how you do that directly to the regulator or through kind of ancillary rights that are granted in the legislation. So rather than simply forcing you to say what you're doing, it forces you to do. The other kind of category that sometimes gets used is a regulatory approach. The customs controls, which are common in the United States and now in Canada, fall into this. So there's been an evolution over the last sort of decade or so in the States of stopping goods at the border that are thought to be produced with forced labor. I'm going to touch on that a little bit later. Canada now has a customs ban of its own, which prohibits the importation of goods produced with forced or child labor. So that's an alternative approach. You might see it as a fourth generation, if you like, but it's not really transparency at all. It's all about stopping goods before they enter the market. Then there's a sort of more classical regulatory approach of having an investigative or administrative body that's empowered to look into the measures that people are taking in relation to modern slavery or human rights. And an example of that is to be found in the Canadian Ombudsperson for Responsible Enterprise, which is empowered to investigate human rights abuses by Canadian companies in certain sectors. Then, of course, there's the leaving it to private citizens and to bring lawsuits essentially through private law rights. So one way that might be done is through introducing a jurisdictional right of action. For a long time, there was something called the Alien Tort Statute in the United States. And it was thought that offered offered a route to that type of lawsuit. That's now been largely kind of shut down by the United States Supreme Court. But other rights of action in other laws exist, and France's duty of vigilance law is a perfect example of that. It offers a direct right of action for anyone who kind of suffers a human rights abuse linked to the reporting entity to sue the reporting entity itself. And then there are common law rights. We've seen the rise of lawsuits, most famously Nevson and Araya, which went to the Canadian Supreme Court a couple of years ago. There are similar cases across the pond in the United Kingdom and all over Europe, where people are essentially trying to hold companies and organizations accountable for things that have happened that are related in some way to their operations or related in some way to their supply chain through private law actions like torts. So that's kind of the table of available approaches. This slide is obviously covered in text, and I always put it up because it's such a long list, and that's really the point. You can see that on the left, we have laws that are in place around the world already. We begin with the Californian Transparency and Supply Chains Act 2012. It's followed in 2015 by the UK Modern Slavery Act. And then there's just a wave of legislation that has been passed in a whole host of different countries, in North America, in Europe, and around the world. And again, when I sort of started talking on this topic sort of 6 years ago, this was a much shorter list. It was growing at the time, but it was still probably half the size that it is now. And I haven't put everything that's out there on the list. I ran out of space on my slide, and I thought it was already too busy with text. On the horizon, the big one is the European Union Corporate Sustainability Due Diligence Directive that I mentioned already. That's going to that is a mandatory due diligence piece of legislation. If it's passed, which is widely expected to, it will introduce those obligations across the EU bloc. So that's going to be kind of a big game changer in Europe. There's also a UN draft treaty that's at an early stage at the UN level. And then there are various national proposals for similar acts, be they transparency acts or due diligence acts. I've put a few of them up there, but there's the key point here is that this is a movement that has only been growing. And Canada is now part of it, as MP McKay said, taking Canada from laggard to leader. So what are the reporting acts under the Canadian legislation, and how do they stack up to what we see around the world? Well, in Canada, let's start with who the Act applies to. And again, this is something that was kind of touched on at the start. Canada has the lowest thresholds of all of the big acts that are out there. I've put some of the best known on the screen. Starting in the top right, you see that in the UK, it covers organisations that supply goods or services with an annual turnover of £36 million. So that's about 62 million Canadian. Going down to the bottom left, Australia has it's entities which carry on business in Australia, whatever business that is, with an annual turnover of 100 million Australian. It's about 90 million Canadian. And then in France, which is the first of the mandatory due diligence laws, we see the thresholds are much higher. So it's companies with a head office in France with 5,000 employees, or alternatively companies who don't have a head office in France, but are established in France under that concept as it's understood in French law, with 10,000 employees. That only applies to a fairly small slice of French companies. In other words, although the French duty of vigilance law applies very strong obligations on those companies, the number of companies it applies to is very small. If we now go up to the top left in Canada's Act applies to entities that produce, sell, or distribute or import goods or control another entity that does so. And in order to be an entity, you are either a public company, you're listed on a Canadian stock exchange, or you're a private company that has a connection to Canada and meets 2 out of the 3 of those size criteria. So what do I mean by a connection to Canada? A connection to Canada means you have a place of business here. Well, that's straightforward. You have assets here. That's also quite straightforward. Or you do business here. That's where there can sometimes be a bit of gray areas. It's determining whether, for example, a foreign incorporated company is doing business in Canada can be a tricky legal question. It depends on a number of different factors. But assuming you do have one of those connections to Canada, and then you meet 2 out of those 3 size criteria, you will be an entity, and provided that you're producing, selling, or distributing goods, or you're importing goods into Canada, you will then have reporting obligations. So those are the lowest thresholds of any of these pieces of legislation that are on the screen. It applies to a much broader swathe of the Canadian business community. There are many, many more companies that will have to report under the Canadian legislation compared to what is the case in the UK, Australia, France. The other thing that I think it's kind of interesting to draw out here is the difference between the types of activity that are targeted by the acts. In the UK, it's companies that engage in goods or services, so services producers like financial services providers, law firms, technical support software companies, all of those would be covered under the goods or services provision. Australia, it's even broader, it's really anybody. So even if you don't fit into a supplier of goods or supplier of services, you'll still have to report, provided you're big enough. In Canada, on the other hand, the Act is mainly aimed at goods. And while there are some grey areas around what a good is and whether it covers things like intangibles, in general, we're talking about physical goods. So if you're involved in selling or distributing physical goods, especially consumer goods, there's no doubt that you will be reporting. But on the other hand, if you are a services company and you don't have any kind of ancillary distribution of goods as part of the service that you provide, you may not have to report. And so that's another kind of key point of difference with the other legislation that we see there. Another interesting thing to look at is what are the rights covered, and this goes back to when I was talking about the definitions before. In the UK, the Modern Slavery Act covers slavery and human trafficking, which includes forced labour. Australia defines modern slavery in the Act. Again, this time it includes trafficking and child labour as well. Canada has we've gone with forced and child labour, but as I sort of explained at the beginning, it really fits in. We're generally talking about different shades of the same color here. All of these are targeting kind of key parts of the modern slavery issue as modern slavery is understood. France and the mandatory due diligence laws sometimes take a different approach. In France, it's not limited to labor rights and modern slavery. The duty of vigilance law applies to all human rights as they are understood in France. So that's another and a point of difference. I'm not really here to draw a conclusion about whether that's a good or a bad thing. You've seen that modern slavery is a problem, is a global problem of enormous size and difficulty already by itself. It's not to dismiss other human rights as being problematic, but there's no reason why you can't have a transparency reporting act like Canada's that would apply to all human rights, and vice versa. No reason why you couldn't have a due diligence act that applied to modern slavery. Those are choices that you make in legislative design. Canada has chosen to target in particular forced and child labour. One of the things I'd point out is the new EU directive that's coming down the pipeline I mentioned before. That actually throws environmental rights into the mix as well. So environmental due diligence is going to be required under the EU directive, which is something that really hasn't been explored in a lot of these other pieces of legislation. So what is the reporting requirement? You deal in goods, you're an entity that meets the fairly low thresholds of the Canadian Act, or you're in another jurisdiction, you meet the requirements there. What do you have to report on? The answer for the Canadian Act is you need to report to the minister on the steps you've taken to prevent and reduce the risk of forced and child labour at any step of the production of goods. And then there are 7 mandatory categories that you have to include in your report. In Canada, you only report for yourself and any reporting entity that you control. So it's not necessarily the case that you report for any subsidiary. According to the guidance that's been put out, you are required to report if you control something that would itself qualify under the size criteria and the activity requirements as an entity with reporting obligations. In Canada, you have to report to the government and publish the report on your website. So these are all things that are treated slightly differently in other jurisdictions. The UK, which is the oldest sort of modern Slavery Act model, as I say, we can go back further to the Californian Act, but that works a little bit differently to the UK, Australian, Canadian Acts. But under the UK Act, there were no mandatory areas you had to report on. There were 6 suggested categories you could cover. And there's no public report that goes to the government. It's just a public report that you put on your website. Australia kind of flipped that around. You only report to the government, and there's a public registry of reports. They also decided there should be mandatory areas on which you should report. So there's 4 mandatory criteria there. The list is actually a little bit longer than that, but 2 of them are just identifying the reporting entity. And unlike Canada, in Australia, you do have to report about what your subsidiaries are doing. You have to talk about what the consulting process with those controlled subsidiaries is. Whereas, as I said, in Canada, at least according to the guidance that's come out from the government, you're only investigating what your reporting entity subsidiaries are doing. So what are these mandatory areas on which you have to report? Well, there are 7 of them. And in some senses, they're straightforward. They largely mirror what you find in the UK and the Australian legislation in particular. You have to describe your structure, your activities, your supply chains, any policies and due diligence processes you have in relation to forced and child labour, any parts of your business or supply chains that you've identified as carrying a risk and how you've sort of assessed that. Any measures you've taken to remediate any forced or child labour when you've found it after you've kind of done the mapping under Part C. I'll skip over E for now. Any training you've provided to employees, that's sub F, and then how you assess your effectiveness in ensuring that forced and child labour are not being used. Coming back to E, this is the one that was introduced by amendment in the Senate that we heard about from the senator a short while ago, and it is interesting. The first thing to note is that this is a key point of difference again with the other modern slavery acts that exist out there. Neither the British nor the Australian Act nor the Californian Act require something like this. And as the senator said, it's essentially saying when it comes to dealing with forced labour, when you find it, you've got to report on more than just what you did to bring an end to it. You've also got to report on any measures you're taking, kind of ancillary or beyond that, to alleviate the problems that might result from bringing an end to the forced or child labour. So as I read it, to take an example, if you discovered you had a modern slavery issue at a supplier or a sub-supplier in your supply chain, and you then decided to exercise a contractual right to terminate the business relationship, that's a fairly common piece of contractual machinery that exists. Well, if that termination with that supplier or sub-supplier would result in kind of a mass layoff and leave the families who depended on the income from that forced or child labour destitute, that's something you may want to turn your mind to. That's whether you're going to take any measures to compensate or cushion the blow of that layoff. That's essentially what I understand this provision to be aimed at. You need to report on whether on the thought you've given to those types of measures. So in other words, as the senator said, you need to report not only on the measures you took to clean the supply chain, but you need to report on kind of the measures that you've taken, if any, that go beyond sort of cleaning the chain. And it may not be limited to compensation. It could include training, community programs, transfers of employment, microfinance. There's a whole range in this area, kind of specialist initiatives that exist and that have been developed in different contexts to deal with forced and child labour when it's found. So this isn't, there's a range of things. And as I say, there's no need to reinvent the wheel here. That brings me to penalties. Really, one of the, again, key point of difference with existing legislation. I've put the Californian Act on the screen this time. You can see that in the middle on the right. Californian Transparency in Supply Chains Act requires you to report in sort of similar to the UK, Australia, and Canada. It's not, strictly speaking, an annual requirement, although if there are changes that you need to report on, you may need to provide an updated report. But the only enforcement mechanism under the Californian Act is an injunction by the Attorney General of California to compel you to report. And in fact, the Californian Act protects you from private lawsuits. There's a safe harbor, there's considered to be a safe harbor doctrine that means that if you disclose something in a report, you generally can't be sued as a result of that disclosure. The UK Act is kind of similar to California in that the only enforcement mechanism that existed under that act was a court action by the minister to bring an injunction to force you to report. Australia sort of took a step back and has no direct enforcement mechanism at all. although it did include a provision that the government can require an explanation or require you to remediate a failure to report, and it can publish a list of non-compliant entities. So there's kind of a blacklist process in Australia. Australia, it's also considered that there's the potential for indirect enforcement through consumer law for making sort of false and misleading statements as essentially false advertising. I'm not aware of any successful cases that have been brought on that basis, but when the Act was coming in, there was certainly analysis done that considered it was a potential risk. Canada's Act it goes very much the other way. As the Senator said before, this is an Act that has teeth. It includes a fine of up to $250,000 for the company itself and any director or officer who is involved in approving or preparing the report. And that is, the offences that exist under the Act are for a failure to report or publish the report, and crucially, for making false or misleading statements in the report. So, in essence, if you are going to report something under the Act in your annual report, you need to have a high degree of confidence that what you are saying is true. Because if you don't, there is the potential that it will later found to be untrue, and you then have potential liability for having made a false or misleading statement in that report. And $250,000, it's a big fine. Certainly sounds like a big fine, but it's the aggregate liability that may apply is obviously more than that. For example, if you have a board of directors on a company that has 10 directors, then the aggregate liability for everybody who's potentially subject to those provisions and those offences is $2.75 million. It's $250,000 for each of the members of the board who approved the report, and $250,000 for the company itself, bringing us to 2.75. So it's there's the kind of, as I say, the aggregate liability is something that can quickly add up, and also where you've got a corporate group situation where you might be making several reports for different parts of the group. If the same people sit on more than one board, they might find themselves with multiple liability risks for each of those separate reports. France is kind of interesting here, as there's two enforcement possibilities under the French Act. Interested parties can apply to the court to enforce reporting in case of a failure to report. There are numerous cases where that's been attempted. There's also, and I touched on this earlier, there's also a direct civil right of action against the reporting company where one of the risks that they're supposed to be dealing with in their implementation plan has materialized and the plan hasn't dealt with it properly. So the French Act created a right of action which didn't previously exist in French law to allow for a direct action against the reporting company. So that's another type of enforcement that we see around the world. It's not the option that's been taken here in Canada. We're imposing direct quasi-criminal fines or administrative criminal fines, but it's another interesting kind of enforcement option that's out there. And I think again, sort of the key point I take from all of this is the type of enforcement doesn't really depend on the type of act. It's not the case that a mandatory due diligence act necessarily has to have the types of enforcement provision that France has included, nor is it the case that a modern slavery act doesn't have to have any direct sanctions either. Canada's just proved that myth kind of wrong by including direct sanctions. So the question of penalties, I think, is an important one, because one of the key criticisms that's been made in recent years of the UK Act is that it lacks enforcement machinery, and there's never been an injunction proceeding to compel reporting. One of the reasons why that's problematic is because the government doesn't necessarily know who those companies are who aren't reporting. It's not immediately obvious. Similarly, as far as I'm aware, in California, there's never been an injunction by the Attorney General, unless that's changed recently. So there we go. So Canada's Act is kind of one of the acts with the most teeth. The other one that maybe has more teeth is France, but it works in a slightly different way, and there's while there's a kind of a range of cases working their way through the courts over in France, it's a real question of watch this space for now as to how well those new rights work. So I'm conscious that I'm burning through my time, but how does one report under Canada's new Act? Reports are due May 31st for the prior financial year. That's something that's found in the Act. You now also have a 10-page limit, or 20 for a report that's submitted in both official languages. That's something that was introduced by the recent guidance. And in addition to the report itself, you have to complete a mandatory questionnaire online. You can find the questionnaire at the bottom of the two links on this page, which there's a drop down that says view questions, and it allows you to sort of see all of the questions you may be asked before you go through the actual exercise of responding to the questionnaire. So that is available online to be seen. The questionnaire is really interesting. So maybe before I talk about the questionnaire, I'll quickly talk about the guidance. Apologies. So the guidance clarified a few things. One of the things I mentioned was on whose behalf you must report, whether that includes subsidiaries that are not themselves reporting entities under the Act. So that's one of the things that's sort of been potentially clarified by the guidance. Also, the Act's applicability, who it applies to. There's a number of helpful things there in the guidance. In particular, the meaning of control. The guidance directs you to accounting standards as well as legal definitions of control there. These are all things that your legal and professional advisors can help you navigate. I don't have sort of time to go through all of the guidance, but there are a number of areas where it kind of clarifies some of those grey areas that had been discussed after the Act had passed, relating to sort of the broad strokes definitions that are there. But the questionnaire I want to spend some time on. The questionnaire it's a big difference with the UK and Australian Acts. In fact, I'm pretty sure that there's no sort of direct equivalent anywhere, and I'd be interested to hear if there is. But it's quite far-reaching in several ways because it requires you to specify the actions that you're taking, and it has long drop-down lists for that purpose. An example is to be found in question 6. So question 6.1 is related to whether you have due diligence policies and processes. If you say yes, you get a pop-up which is 6.1, and it says, which of the elements of the due diligence process has the entity implemented in relation to forced labour or child labour? Select all that apply. And there's then a kind of a drop-down list which includes 6 different options, of which you can select all or none. And those cover such things as embedding responsible business conduct into policies and management systems, identifying and assessing adverse impacts in operations, supply chains, and business relationships, ceasing, preventing, or mitigating adverse impacts, tracking implementation and results, communicating how impacts are addressed, and providing for or cooperating in remediation where appropriate. What I find interesting about these questions is they obviously lend themselves to creating a database of how much of kind of the comparative levels of compliance between companies. So when you've ticked a box, I'm sure that that's going to get stored in a database somewhere, and you'll be able to pull up statistics of how many companies are doing all of the things under question 6.1, how many of them are doing just one, and how many are sort of somewhere in the middle. But what I find, what's kind of interesting about it is it sets out a number of sort of well understood categories of due diligence. And so there's the potential here, I think, over time for questions to be asked as in terms of where companies that have to report are progressing. Right? If in the first year you only tick the box that says you're embedding responsible business conduct into policies and management systems, that might lead down several years down the line to questions about what other things you're doing according to those categories that exist. But another kind of interesting one is question 9. That asks you to select what sectors and industries you've identified forced and child labour risks. And again, it has a whole drop down list, things like agriculture, services, manufacturing, construction. So it goes kind of a step further than the mere requirement to report. If you've read modern slavery statements under the British and Australian Act, you'll see that a lot of those descriptions take place at a fairly high level. So people describe their supply chain in pretty broad strokes, and then discuss the general due diligence processes that they may have put in place to identify and address for modern slavery within those supply chains. But it doesn't require this kind of pinpoint precision that the mandatory questionnaire is now requiring, in saying, I've taken this type of action and this type of action and this type of action, or I've only taken one of these 3 types of action, or I've done none of them. The mandatory questionnaire is now requiring you to sort of to identify those things, and even to identify which sectors you've identified as problematic within your own supply chains. Question 11 is another one of those. That's about remediation measures. So what remediation measures has the entity taken? Again, as it says, select all that apply, and there's a drop-down list. The first one says actions to support victims of forced labour and child labour or their families, such as workplace reintegration and psychosocial support. Number 2 is compensation for victims of forced or child labour and their families. 3, actions to prevent forced labour or child labour and associated harms from reoccurring. 4, grievance mechanisms. 5, formal apologies. And 6, other, please specify. So again, I can sort of foresee a future where there will be discussion around the number of reporting entities that are or are not doing some of these things. In particular, the first 2, which obviously go beyond just cleaning your supply chain, that's talking about compensation actions to support victims. So if you're not ticking those boxes, there may be it may be something that you want to consider as things progress and move forward. So the mandatory questionnaire, I think, adds a layer to reporting that hasn't existed in some of the other jurisdictions, and that is probably going to have a focusing effect on both the types of actions that people will expect themselves and their suppliers to be taking, and which may also build into the idea of reporting over time, the expectation being that if you're reporting on, we're considering introducing policies next year, then the following year you may say we've introduced policies, and the year after that you may talk about embedding those policies in a number of ways. So that kind of idea of a progression and a leveling up as over time as reporting goes on. This slide is, it kind of goes to some of those things that are mentioned in the mandatory questionnaire, in fact. This is just an example of what due diligence looks like. So I do want to take a step back from both the mandatory questionnaire and this to reiterate that although the questionnaire exists, it doesn't, you can give a nil response to some of those drop-down questions. You can not tick any of the boxes. You can say you're doing nothing. The Act doesn't require you to do any of the things that are on this slide as well. But this is kind of an example of what social supply chain due diligence may look like. It would include some or all of these elements. So, starting at the top left, you might look at what the regulatory framework is. Here in Canada, that's the new Act. Behind the new Act, you obviously have international standards like the UN Guiding Principles and the OECD Guidelines for Responsible Business Conduct. The ILO declarations as well play in there. That's going to define the type of due diligence you're doing. Then there'll be, then you might take a step to map the supply chain to see what are the potential risks that we may be dealing with and where might they be located. Then there's risk prevention. That's kind of a level up from simply identifying where the problems may be, to say, okay, well, how do we either apply pressure to our suppliers or our subsidiaries to prevent this, or how do we take other steps to kind of see how we can address some of these risks. Then there's response and remedies. That comes back to the sort of remediation process we were talking before. Tracking and monitoring. So whereas in some cases you might have certain rights to inspect and audit, do you track and monitor things on an ongoing basis? And then communicating, well, that's required under the Act. But I think the real point of this slide is not to get down into the weeds too much of all the things you might want to consider if you're an enormous multinational with unlimited resources and you want to have a zero modern slavery supply chain. It's really to point out that this is a kind of cumulative process that builds on what you have. If you have nothing, you probably want to start at the big green arrow in the top left and say, well, what are my obligations? And as a result of my obligations, you know, where do I want to start with this process, so that in my report I can aim for the level that I need to, given my business and reputational requirements. If on the other hand you're a company that already operates in a highly regulated industry, you may have a lot of this already, right? You might have a sophisticated compliance framework and risk management framework. If you, for example, you work in pharmaceuticals or in food, these are areas that have high levels of regulation already. And so there we're really looking at sort of what things you might want to tack on to your existing frameworks in order to be able to report in the way that you want to report. And the other thing I sort of want to mention is there's obviously an interesting interplay, because this is a Transparency Reporting Act and not a Due Diligence Act, between what claims you need, what your assessment of your business risk is in terms of how you need to report. So do you need to be able to claim for the purposes of your business that you've got extremely clean supply chains, versus what's the work in the background that you need to do in order to have the confidence in those claims to report and to manage your liability risk. So there's a real back and forth between those two things that I think is kind of quite interesting, and it's an important part of how to look at and approach reporting at a practical level. Now, I fear that I am out of time, so I'm really not going to touch on the customs control and the Canadian Ombudsperson, other than to say they exist. The customs ban has been on the books for 3 years now, and there was one enforcement action. It was successfully challenged, but it's still a question of watch this space. CBSA has a D memorandum that is currently under consideration for update, which deals precisely with this import ban. There's obviously enormous enforcement of similar provisions south of the border in the US. There have been hundreds of thousands of sieges under what's called the Uyghur Forced Labor Prevention Act. And there is pressure on Canada to start enforcing its similar provisions up here. CORE, as I said, it exists to investigate certain companies. So it's only empowered to look outside of Canada and only in the garment, mining, and oil and gas sectors. But as MP McKay kind of said, I do foresee the potential for some interesting interplay between the reports that may come out of the Ombudsperson and the reports that are made under the Forced and Child Labour in Supply Chains Act. Again, in terms of managing long-term risk, people are going to have to think carefully about the report they might be making today under the new Forced and Child Labour Act, and what the potential results of an investigation by the Ombudsperson might be 2 or 3 years down the line, and what that will say about the truth of the statements that were made in this original report. So there is definitely going to be an interplay between those institutions, and I think that's going to be something to consider carefully in developing approaches to this act. So that's kind of my whistle-stop tour of the Canadian Act and how it stacks up to global legislation in this area. You've got a nice picture of my ugly mug up on the screen and my contact details there. If you do have kind of detailed questions that require legal advice, I'd be happy to help you with any questions that you may have in relation to the legislation. And now I think there's that we're going to move on to some Q&A if Errol thinks that we've got time.
Yes. Thank you very much, Benedict, for the magisterial overview of not just the Canadian legislation, but also several others. So thank you very much. In answer to some of the questions that was raised, yes, we will be in touch with you as to whether or not we can send forward the recording plus anything else connected to this event. I've had close to 40 questions, which we don't have the time to get you to answer, Benedict, but maybe I'll sort of summarize a couple of them and mash them together to give you the ability perhaps to answer in a few sections. Several have basically asked whether or not, to what extent, because there's a law applied to services where they basically don't import or have products come in, but they advise. I guess you're talking about financial institutions, you're talking about loan arrangements, etc. So that's one. Another one, which basically asks, in terms of the holding company and the subsidiary, if the holding company is doing nothing else but just basically having shares, do they have to basically go through the same process as the subsidiary? So there's this whole issue of the relationship between holding and subsidiary. There's a whole bunch of others in terms of, and this is going to be interesting for universities too. What are the range of public institutions that are covered, going from universities which may be importing goods, and do they qualify in terms of the cutoffs? Likewise, this one I'd be very interested to know if any of these municipalities even know that they're covered. Do municipalities who actually own corporations or somehow control them, do they end up being mandatory to report? So there's a whole bunch of areas which are not normally thought of as being relevant to this act. But for those of you who, I'm speaking to the audience, who don't have the answers to the questions you raised, you'll be pleased to know that Benedict has promised that there will be a follow-up to this. And we will be bringing back Benedict at some stage in the future where we can go into much deeper into the weeds of this act, maybe to answer some of the other questions, which sadly we don't have time for Benedict to answer. There are a couple of other ones which I think will require a lot more discussion and analysis. But over to you, Benedict, if you can answer a few of those in a short space of time.
I mean, I think I was kind of taking a look at the Q&A as well earlier before my time to present came on, and I think one of the things I want to emphasize is that a lot of these questions aren't the easy ones, and I'm a member of two kind of working groups with lawyers who are grappling with this subject. One at the CBA, the Canadian Bar Association level, and another one that's sort of more ad hoc, and we spend long periods of time debating some of the nuances of these real grey areas that exist in the legislation. And that's something that's totally normal, right? It exists with every regulatory regime. The more prescriptive you are, the more things become difficult in those very narrow categories where, where sort of fortunately or unfortunately, some people tend to fall, and the answers to the questions become less obvious. So the services and goods one is kind of interesting. There's the first thing to mention is that although the guidance talks about very minor dealings is phrased as very minor dealings. It's not phrased as minor dealings, and it's not phrased as, there's no sort of threshold that's specified there. It doesn't say that minor dealings is different for a huge corporation as opposed to a little SME that maybe only has 40 million in revenue. So while there's some uncertainty about what minor dealings means, I think it means you've got to be very careful excluding anything when it comes to dealing in goods. If it's something that you offer to the public or some sort of supply arrangement that comes with any sort of regularity or frequency, or it's just dealing in the thousands or the tens of thousands of dollars, it's unlikely to fall into that get out clause of very minor dealings. So what does that? Why did I start there? I started there because that means that as soon as you're dealing in goods in any way, shape, or form, it doesn't matter that your primary business might be services. You're still going to be caught by the reporting obligations of the Act, provided that there is some activity in goods that fits within the Act. So, for example, if you are a repair outfit that repairs machinery or vehicles of some type, and as part of your repair services, you supply goods to replacement parts and things, there's a high likelihood that you're going to be reporting, even though your primary business is repair services. But there's a supply of goods that takes place as part of that relationship. The same with things like hire purchases situations. Like I've had clients reach out to me asking, well, again, I'm some sort of services business, but I have these particular types of hire purchase or loan arrangement that do relate to some form of good. Do I have to report? And as I say, the answer to that question is not always straightforward. It tends to, a lot depends on the precise kind of facts and what the agreements you have in place and what they say about who owns what and the transfer of title and things like that. So sometimes the question gets quite complicated, and then that's when I need to take away my disclaimer and start sending you some invoices. But sort of in the easier question to answer is, if you have some sort of provision, if you sell consumer goods as an ancillary part of your business to the public or to your customers, it really doesn't matter that your primary business is not the sale of goods. You're likely going to be required to report. If you import goods into Canada and it's beyond a minor dealing, it doesn't matter if you're selling them to anybody. If they're for your own use, you're going to be caught, because the importation provision is separate to the sale, distribution, and production provision. And to answer the question of if you're importing, that one's again kind of a straightforward one. It's become a little bit more straightforward with the guidance, but I was happy when the guidance confirmed the advice I was giving to people before, which was that if you're the importer of record, so if you're the person who is responsible for bringing goods across the border and accounting to them to CBSA, whether or not you owe duties, there may be zero duty goods that you're bringing across, but whether you're legally the person that would be responsible for those duties if they existed, then you're the importer of record, and you will be importing goods into Canada. Again, things get difficult at the frontiers, right? There is a well understood kind of concept of non-resident importer, where it's actually the foreign company that's selling you the goods that may, in some circumstances, be the importer of record, bringing them across the border into Canada. But in most cases, it's straightforward. And in most cases, it's usually the company receiving the goods here that will be the importer of record if we're talking about kind of any kind of large scale purchase or supply arrangement. So that's sort of my answer to the services and loans question. I mean, I think pure services are excluded, right? So if you're a services company, say a financial services company, you don't sell any goods to your customers, you don't distribute goods to your customers, you don't import, you buy all your equipment for your own use from Canadian distributors within Canada, then you're not selling, producing, or distributing, and you're not importing. And so there you will likely not have to report. The holding company question, this is one that keeps coming back for debate in the working groups I mentioned. In essence, you need to draw a distinction between the reporting, the entity that you control, and the holding company and what it does. First of all, it's obviously possible to do a joint report under the Act, and you're given, the Act explicitly gives everyone that option. You can choose to do a joint report or a separate reports. If you do a joint report, you can also choose who signs off and attests to it. So you can have each organization sign separately, or the parent holding company can sign on everyone's behalf. There's different factors that play into making that choice between a joint and separate report, but assuming that you're doing separate reports, so you have subsidiary, reporting entity subsidiary doing its report, and then above it you have the holding company doing its report. The holding company doesn't necessarily need to report on everything that the subsidiary is doing. It depends on what the activities are, because the Act requires you to report on things that on reducing, preventing and assessing forced and child labour risk at any step in the production of goods. But there's generally an expectation that you're not going to be overly duplicative, and the holding company may wish to focus on things that are happening at the particular holding company level. Right, a good example is where you have a group due diligence process that's run and mandated by the holding company and that all subsidiaries have to comply with. That will be something that you will have to report on at the parent company level, because it's run by the parent company. If, on the other hand, your reporting entity is the one that runs that due diligence and you really are a pure holding company, then you may have less to report on. You may be saying we own this subsidiary, they have robust due diligence processes, etc., as described in their separate report. And we place our faith in those processes. In addition, we've taken, we have the following provisions that apply to our suppliers and that we expect our subsidiaries to comply with as well. So you're talking, that report may look more limited. It may be more limited to initiatives that come out of the holding company level and that are mandated from a top-down perspective. But it does get, there's certainly an area where there's room for interpretation. And again, you may need to think carefully about what goes into each of those reports. But in general, the guidance seems to suggest that you don't have to do the same report twice. You don't have to report on every detail that the subsidiary is doing in the parent company report, assuming you're doing separate reports.
Thank you, Benedict. That was a valiant attempt, which just on that last issue, we could spend a whole hour on it. So there's lots and lots to discuss. And as I mentioned to the audience, this is going to be just the first of several, which both the University of Ottawa's Professional Development Institute and my own organization are collaborating to make sure that we get as much into the weeds as possible so that we actually end up doing justice to what the Act was all about. And hopefully that'll basically be something which you can look forward to in the future. So I do want to, first of all, thank Benedict for, again, in addition to his presentation, to answer those questions off the bat is amazing. So on behalf of both the audience and the organizers, we really want to thank you, Benedict, very much for your presentation. And no doubt we will have you back to answer some of the questions which we haven't answered in the future. So with that, I do want to, thank you very much, Benedict. So I do want to hand over to the head of the Professional Development Institute to give his final words before we call it a day to everyone. As I mentioned, there will be communications with the audience and everyone else in terms of what we can share with you and what we may not be able to share with you. And I'll hand that over to Serge to say the final one from the University of Ottawa, who we just found out could actually be part of the reporting requirements too. But over to you.
Precisely. Yeah. Yeah, thank you very much. Wow, what a conversation. I mean, I thought it was going to be very dry, and it is to a certain extent, but I mean, so consequential, way more than I thought it was, hugely important and timely. So listen, thank you very, very much, of course, to our stellar panelists, and to you, Professor Mendez, thank you for making this happen. This was your idea, supported by Slava. Thank you to Paul and Sonia, working secretly behind the scenes here, but making it all happen. And of course, thank you all to the participants, 300 people or so during the webinar today. And judging by the number of questions, I think there is huge interest. I'm happy to hear you, Errol, to say that this will be an ongoing series kind of thing. I encourage you, without without sounding like a salesman, encourage you to look at the other programs that the Professional Development Institute offers at the University of Ottawa. So there might be things in there that your company, your organizations would like to benefit from. But to be sure, this is a topic that we will keep very high on the list of future topics to continue working on. Thank you very, very much again. Merci beaucoup, Monsieur Errol, and have a nice day. Thank you. Bye-bye.